Zachary Adams, motion 48, joining that motion. Also, Zachary Adams, 21, to consider all objections under both state and federal constitution. Zach Adams, motion for higher standard of due process. I've already mentioned at the outset that the court is aware that there's a heightened due process in death penalty cases. I will apply the applicable law to each motion on a motion-by-motion basis. Zachary Adams, number 2, motion to sever trial of Zachary Adams from Dylan Adams. State earlier filed a motion to sever. I'm reserving any severance until the court makes certain other rulings, because those rulings will impact whether we have 1, 2, or 3 potential trials. So motions to sever will not be ruled upon at this time. Number 7, Zachary Adams, motion regarding hearsay. Motion seeks to have the state specify any hearsay it intends to present as evidence in order that a pretrial ruling in limine may be had on the admissibility of the same. Motion seeks to have the witness admonished to refrain from the admission of hearsay testimony prior to the court's ruling. I intend to follow the rules of evidence. And all I can say is that if you think that something's hearsay, you need to object based upon hearsay prior to the witness attempting to respond, and I'll make sure the witness does not, and then you'll get a clear ruling on it. Motion number 16 of Zachary Adams, motion to instruct the gallery. Court seeks to have the court admonish the gallery and spectators during the trial prior to each session and out of the presence of the jury to refrain from audible commentary, visible reactions, emotional displays, or outbursts during the presentation of evidence before the jury, and to prohibit the wearing or display by spectators of any insignia, symbols, pictures, clothing, or other items that might influence. The state believes this motion is unnecessary and the court may manage courtroom decorum. I addressed this at the very outset. I intend to basically maintain proper decorum in the courtroom. I will not suffer outbursts in the courtroom. There will not be T-shirts, other things in an attempt to in any way influence jurors. I think we got problems anyway with jurors influenced by a T-shirt or a ribbon, but the court won't suffer it. I recently tried a case in Benton County that was not nearly high profile, and I just caught the people coming in and they had certain types of shirts on. I said, cover them up. You're not going to do that in the presence of this jury. So court intends to maintain proper decorum. Zachary Adams, number 18, motion to prohibit display of exhibits until admitted. I'm not sure exactly. I'm going to, in other words, opening statements, parties might wish to address something, but an exhibit is not evidence until it's properly admitted by the court. And I'm going to ask that the parties carefully watch what they make reference to. Recently, I had in a case a PowerPoint display that I think probably went beyond what it should have concerning evidence. The jury's always instructed that they'll rule only based upon the evidence in the law, but I'm going to ask that all parties guard in their opening statements. Getting too far out on a limb is what I'm saying. Zachary Adams, number 19, motion to establish procedure to view exhibits. I'm not sure exactly what that is. Prior to anything being authenticated or moved into evidence, certainly counsel for each side have a proper opportunity to look at that. that really should be done pre-trial in order to expedite. I'm assuming she reminded me that's when the attorneys were viewing certain things at different physical sites. Yes.
Yes, Your Honor, that was for us to, the court to give us some instruction as to how it could be that the parties could look at the evidence that's in the custody of the state. We refer to it as exhibits because on many of the lists, the state had referred to items as exhibit numbers. But it was just we were looking to the court to provide some guidance as to how it was we were to look at that.
Has this been resolved?
It has not been resolved, Your Honor, no.
Then I expect the parties in a professional manner to resolve it.
Yes,
This is not something that should require court intervention. You have the right to have a certain amount of privacy while exhibiting. This is where it's going, but it's not unfettered.
We didn't ask for unfettered, Your Honor. We would like to view the evidence without the prosecutor present. There could be an agent or somebody else present, but the prosecutor's office doesn't review evidence with us present. We would like to be able to review the evidence without the prosecutor present.
Can we designate an agent to take care of this?
Excuse me. The problem, Your Honor, with what counsel is requesting, and we have actually attached photographs to our response showing the thousands and thousands and thousands of items. Every single time one of those bags is open, it requires one agent to open it, one agent to take it out, to display it, another agent to repackage it, to move on. So we were all doing it at the same time. The state was not hovering. And it's interesting because all of us were present to avoid tying up the entire agency, TBI I'm referring to, for days and days and days and days. The only person who complained is Zachary Adams' attorney. It was fine with everyone else. They were free to stop the process, to go and confer, to look at something, to photograph it. It is a near impossibility to ask TBI to do what counsel's requesting. In terms of designating an agent, and frankly, one of the requests was that an agent be designated that didn't have anything to do with the investigation. I'm not sure where all this personnel is supposed to come from, but we did our very, very best to make sure we did it.
Did we have any problems with the procedure?
I did not, Your Honor.
All right. Y'all have any problems with the procedure?
Your Honor, it was my understanding at the time that we could come back at a later time.
Yes.
And review individual items if we needed to.
Okay, the court finds that the state is sufficiently complying with what the court feels should occur, and you might have to come her way a little bit on this. Okay?
So it's possible that the district attorney stands next to me. I mean, at some point, the district attorney will stand next to us.
I don't want it like the Saturday Night Live skit of Trump right behind Hillary following her around. She's got some, you know, we're human beings. You'll be given a certain amount of privacy, okay?
Yes, sir.
All right. Zachary Adams, motion to continue, overruled. Related motion, Jason Autry, motion to continue, the trial date set April 3rd. I had mentioned at the outset that since Mr. Autry's attorneys came into the game later, that we will not hold them to that April 3rd date. They will be held, however, to the July date. You came in following two other attorneys. Mr. Shaw came in first, and then Mr. Parrish came in. You folks were later into the game, so I think I can give you at least that much relief. You will not be that first trial date, okay? I think that's it. Anything else? She'll get you an order. If we did not cover your motion, call that to the court's attention, and the court will do another order covering your matter. All of these are basically, they're non-evidentiary. It will get much more complex when we're taking up evidentiary motions, but I think for the purpose of today's hearing that all these matters have been covered.
looking at it the first week of July, correct, Judge?
No, it's toward the last of July. 10th? Oh, I got this neat book here. No, July 10th. July. July 10th.
That's the alternative
I got July 31st. I can do it the 10th. What did y'all get?
We have it the 10th.
I had it early.
Yeah.
I had it the first week of July.
The first week in July was discussed as potentially starting jury selection the week before trial was supposed to start on the 10th. But Your Honor did not ever definitively rule. I think most of us just sort of blocked it off, waiting to see.
I think we talked about coming in and taking the jury a little bit earlier.
But there was some question about it with it being July 4th week, but we did have that discussion, but the 10th was,
All right, July 10th will be our trial date. What have I said repeatedly? She's telling me I've got grand jury in Hardin County during that time. Well, guess what? I don't either. I've told you folks, you've got priority on this case. I've said that from the outset. This case has absolute priority, and once we get things going, I will not be interrupted. I don't think I'm going to. First trial date is April 3rd. That could apply to either John Dillon Adams or it could apply to Zachary Adams. Autry, I'm telling you, I'm giving you till July 10th, okay?
Your Honor, I didn't discuss Autry motion number 30. If you'll grant that, we'll just probably speed things up. Otherwise, we could hold that in debate.
What is 30?
For you to strike like that,
Motion overruled. I told you I'm following existing law,
yes, sir.
and so you can, that motion be deemed
We
overruled.
wouldn't object you creating some new.
I'm all for it.
I feel, everybody over here is.
crickets over here.
Do what?
Cricket.
Right now, please.
No, I'll let you preserve your arguments there. All right, anything else? And I think I mentioned down the same avenue, we're not having two separate juries. It's bifurcated for penalty and sentencing, but we're not having two separate juries. I'm not prohibiting from going into death penalty with voir dire with the jury panel. I think those were part of the motions, but I told you as we went through that I would follow existing law on that.
Yes, sir.
All right, anything else? All right, no need to kill a bunch more trees, I don't guess, but, and this is only a portion of what I've got.
All right.
and then we all, he started doodling, and I was like, I was trying to.
We'll try to see that.
Thank you.
Hey, I want to ask y'all something. Do you think ask for the hearing inspection? We don't. I'll be right back.
All rise. Decatur County Circuit's Court now is in session. Honorable Judge Green McGinley presiding.
Be seated, please. Just a few preliminary matters. First of all, we've got all three defendants. Got you seated where you can communicate with counsel should you need to. I will tell the defendants you are not to communicate with anyone except your lawyer or directly with the court. Okay, we understand that? Mr. Autry, you understand that? No communication with anyone other than your attorney or the court. You understand? And then Mr. John Dillon, you understand that? All right. There's a slight change. Most of our motions today are the more technical motions. They're not evidentiary motions. Those evidentiary motions will come later. These are essentially, I would classify them as housekeeping motions, but I will tell the attorneys, first of all, I'm guided by Tennessee law. I don't make law, I follow law. I'll be guided by the Tennessee Code Annotated, case law, the Tennessee Rules of Evidence, as well as the Tennessee Rules of Criminal Procedure. A lot of the motions that have been filed address issues that are actually addressed in those rules. I'll touch on them as we go through, but those rules are what will guide the court. There's a slight change. Our next potential hearing date, I originally had said December 13th. That's in conflict with Chancery Court here in Decatur County. We've got limited facilities. There's one courtroom, and I've got additional time so I can defer to the Chancellor on that day. I also avoid setting things in Decatur County on Mondays because that's the traditional General Sessions Day, and Decatur County is not high volume, but I don't want to deprive that General Sessions of their opportunity to move their cases through the system. So our next potential date here is December 14th. I've got 3 days available at that time, although I don't anticipate that it will take 3 days. If we don't accomplish in those 3 days, the following week I cannot be back until the 21st. That's a Wednesday.
Judge, I
Yeah.
will not be here the week of the 21st, just to let the court know, but I don't think we're going to go past 3 days.
Okay. I'm sure you've checked me out before with fellow lawyers or judges. You're not going to go past 3 days, okay?
I don't think we are.
So I'll just let you know that. But if it appears a problem, we'll work it out, okay?
Thank you.
And then there's potentially some dates I can make myself available, and some of that will depend. You've got a motion, Mr. Maddox, for extension of time to file a motion to suppress. And I'm worried that the timing of your motion could trigger response and potential examination by the state that might put us past that December date. When can you have your motion to suppress ready to file? I'm just anticipating. Am I anticipating correctly?
You are, Your Honor. That can happen.
Your Honor, upon discussing with the co-counsel, we think we should be able to have that filed, no later than November the 30th.
Okay, that will potentially jeopardize that December date. We'll cross that when we get there. I will tell you I've got January, I got 3 days starting January 11 available, and also, what did we say in February?
The 6th, 7th, and 8th.
6th, 7th, and no, see, the 6th won't work, 7th and 8th in February. 6th is that Monday. So, file by November 30, state file their response, and then we'll calendar it for hearing on one of those potential dates. If the state makes a motion for evaluation in response to their motion to suppress, then that will be granted ample time to get that done. And we're also dealing with holidays, which makes things iffy for all parties concerned. So I've already issued an order on some of the motions that were purely technical. John Dillon Adams motion number 1, to require the state to comply with provisions Tennessee Rules Criminal Procedure 26.2 is granted. There's already been an order to that effect. John Dillon Adams motion number 6, notice and motion under Rule of Criminal Procedure number 16, and Zachary Adams has motions that are piggybacking. It's Zachary Adams number 30, Zachary Adams number 35 for discovery and inspection. There's already been orders entered on those. John Dillon Adams motion number 6 under Rules of Criminal Procedure 24B2 and 24H. Zachary Adams motion 36 joining for individually sequestered voir dire. There's been a motion entered as to that. We will have individual voir dire certainly on the issues of pretrial publicity, hardship, death penalty. And I will address later, but the court's open to questionnaires that will hopefully expedite these issues that can be filled out by jurors pretrial.
What was
And
the last number, Judge? I apologize. And the,
John Dylan Adams, motion number 7,
okay.
and Zachary Adams, 36.
We also included these 3.
Oh, the state's motion for reciprocal discovery was granted, and Jason Autry concerning reciprocal discovery and disclosures of experts. The state's complied with disclosure as to all 3 defendants, so you can show that that is granted upon their, they've already complied, because I've got a bundle as to all 3 of the defendants on that. Matter of fact, it scared Miss Carroll to death when she looked, and there was 200 and something pages from the state. But that included correct.
Judge, if I may, there was an order that came out that you had for November the 7th, I believe. I think by the time we received it, we may have passed on the deadlines of November the 11th, involving the experts.
It's this one.
That was on the state's turning over experts to testify in terms of opinion and interference.
They've already turned it over. I was talking about 24B2 and 24H, John Dylan Adams, Zachary Adams, number 36. As I said, that's individually sequestered voir dire is granted. Motion for change of venue will not be granted at this time, but the parties can assume that the court will grant a motion for change of venue at some point. I want to leave it in this county as long as I can, because convenience of family members of the alleged victim, as well as defendants and interested parties. So we will not change venue until on down the road, but I will tell you, venue will be changed.
That's understandable, Your Honor, but I'm going to make this request since we're talking about venue. I would ask that there are ribbons and things all over the.
This is a good time to do it. It won't affect the court.
Correct.
But it potentially could affect jurors. There will be an order of decorum that will be filed where this case is to be heard, and I will not tolerate signs, placards, T-shirts, anything like that that could be perceived as trying to influence prospective jurors. So that will go into effect wherever the court deems the appropriate venue is. And I will go ahead and tell you, just for thinking purposes, the physical change of venue in all likelihood will be Hardin County. I've already explored security and other issues. We can have very, very good security. We can, the housing of jurors can be taken care of so that they'll be sequestered appropriately. There will be alarms on the elevators as well as the stairs, and sequestration of jurors can be accomplished there.
And Your Honor, I neglected to advise defense counsel and Your Honor, but I have received notification from the Department of Homeland Security for the courthouse, and I have the number that your person to give to the sheriff or whoever you designate to get it there.
There will be metal detectors, as well as x-rays,
Right.
and potentially the dogs might be run some.
Well, they said as soon as you tell me who to give that information to, pass it on, and they'll call and have it physically relocated.
Okay. I'm also reserving the issue of where the jury is to be impounded. It could potentially be Hardin County. One of the attorneys suggested Shelby County. Anyway, further than Fayette, they suggested Shelby. That issue is still open, so we'll wait till we're closer to. No filed motions. That's the one that Zachary filed a motion 28 to adopt. I've asked that, and ruled earlier, we don't do a blanket motion to join all motions. They specifically will file that they're joining motion number, whatever it is. Zachary Adams' motion regarding Rule 1006, Summary of Reports Document, filed the same motion. And the related motion is Zach Adams, 60, joining Autry's 25, that is granted. Motion for bifurcated jury, 15 on Zach Adams, Jason Autry, number 18 for separate. I think I have ruled on that, but I will follow Tennessee law. We don't get different juries for penalty phase and guilt phase. Jurors will be voir dire as to the entire trial. That will not be bifurcated, and then extra alternates so that we can cross death penalty when we get to it. So I think I've already ruled on that, but that will be what the court's ruling is. Motion for jury questionnaire, that's Zach Adams, 15, Jason, 19. State also, Zach Adams, motion 54. Jordan Autry, number 9, and state has filed a motion as well. As I indicated earlier, I intend to use jury questionnaires. We will reach agreement between all parties. In other words, probably I will get Ms. Jones to first fire across the bow and then send it to each attorney for suggestions or narrowing or whatever. I think we should be able to agree without any problems. Zach Adams' motion should be closed. That's absolutely established in Tennessee law that when we're before the jury, there cannot be any indicia that any of these defendants are incarcerated, because that's been ruled to perhaps detract from the presumption of innocence. So at the time we go to trial, each of the defendants, however they're tried, will be allowed to be submitted closed. Makes no difference on a hearing like this today because the court's ruling, and it makes no difference to me what their apparel is. Zach Adams' motion to dismiss, because I think that's where he said that the, and Autry's motion to dismiss on the grounds that no grand jury voted to return to Zach Adams, all of them. That's contrary to existing law. The grand jury doesn't have to vote on death penalty, they just have to vote on the criminal charges. Of course, we ruled on Zach Adams, motion 24, to dismiss based upon Gossip versus Gross. As far as Jason Autry, there's a motion for state to seek intent to seek death penalty. I don't remember what that is, but the court's already ruled on that. Jason Autry, number 17, motion for jury panel summons specifically for this case. Did I run on that or not? It depends on where I get my jury. If the jury comes from the same place of change venue, it will be a separate jury summons specifically for the case. If I go to Shelby, Chattanooga, another place, it might not be specifically summoned. I might be drawn from that pool. All right. I said it was granted, but it's subject to those qualifications, okay? Because there's no need for Chattanooga to have a separate summons for whichever case we're trying. Shelby, they've got that auditorium down there that's filled with jurors. What I have done in the past when I was over there, I met with the jury, handed out questionnaires in the morning, had them fill those out, and then we started jury selection actually right after lunch. I ruled rule on Jason Autry's motion for probable cause hearing on the existence of aggravating factors. The state has a motion for notice of alibi defense, which was granted. Motion, the state has a motion for notice of defense based on mental condition, which is granted. Get into the discovery-related motions. Dylan Adams filed a motion to produce exculpatory evidence or information which might lead to exculpatory evidence for the defendant. The state filed a response that court kind of questioned. Without a theory, without a statement from the defense as to the theory of defense they would be pursuing. I don't know anything under existing law that would require a defendant to disclose to the state a particular theory of defense. The court is ruling that the state must, pursuant to Brady, produce evidence for each defendant. And I'm very serious about that. I don't expect any problems. You folks are used to doing that. So let's not play it close to the chest. Anything that is of any question whatsoever should be turned over to the defendants. And I'm aware from various things the court's done that states, through their discoveries, fully compliant. Let me just say that. As to some of the potential theories for defendants, the state has been very forthcoming with other potential defendants and other things that have been raised in motion. I expect them to continue, and then there'll be a continuing duty to disclose as we go through. Dylan Adams' motion in limine under Rules of Evidence 404, 405, 608, and 609. Zachary Adams also joined in. Your motion 32. Motion seeks a pretrial or jury out hearing for any reference to any prior conviction or bad act of the defendant. Certainly that is required. The defendant seeks an opportunity to be allowed to cross-examine any such witness in a pretrial or jury out hearing. And the state has responded that it is mindful of its obligations and expects the court to follow 404, 405, 608, 609. But they state that the motion exceeds the provisions of the rule. Also, it refers to open discovery. I will be following those rules to the letter, so just expect that. Zachary Adams also had motion number 9 in response to 404. Request notice at least 90 days pre-trial of 404B evidence and seeks pre-trial rulings. Seeks that the state will admonish its witnesses not to mention the same prior to a bench conference for the sake of trial. State responded to that same as above and asked that the motion be denied. We're going to try to rule everything we possibly can pre-trial so that it will facilitate the case moving along, because it's going to take a long time to try doing the best we can. Jason Autry, motion for pre-trial disclosure of evidence of other crimes, wrongdoing, acts, and for a pre-trial hearing that would be granted. Motion for pre-trial on the record findings pursuant to 403, 404. Zach Adams joined in that, joining Autry. Do everything I possibly can in pre-trial. Got to go across that legislation. I'm hopeful that the parties are having some type of dialogue for resolution of the case. That's up to the parties, it's not up to the court. So when we get down closer to trial and we realize if we've got 1, 2, or 3, which I don't know yet what we've got to be tried, then we will set time deadlines for pre-trial motions to be argued so that it can facilitate. All right, Dylan Adams has a motion under Tennessee Rules of Criminal Procedure 12B2C. Zachary Adams has motion 33, joining John Dillon's number 4. that you're gonna have filed on November 30th.
Yes, Your Honor.
Is it
That, it will be
state?
supplemented, this is just.
Okay, all right, so you know what court ruling is on that.
Yes.
Delano's number 5, motion for introduction under Tennessee Rules of Criminal Procedure D2. Zachary Adams is number 34, joining this motion. Defendant seeks a Rule 12D2 notice, which the state has already filed. The state did reserve the right to supplement the notice as reasonable and necessary to pre-trial. The state has indicated in its notice that because the issue of severance is currently pending, same notice has been filed as each defendant, and the state points out that any co-defendant could be a potential witness for the state. The state also noted that it will continue with open file discovery.
Judge, I'm just going to assume, just for the record, that each of these, some of them are obviously entitled differently, that most of them are saying are granted for with regards to basketball.
Yeah,
I just want to put that on the record.
Absolutely.
Thank you.
If you want to, just one order say that I can follow law. Okay, because it's just technical crossing T's and dotting I's, and a lot of that has to do with the enhanced standard that goes with death penalty cases. Normally, I wouldn't be pleased that the attorneys are killing the number of trees they are, but I understand, okay? That will be granted, is complied with by their request. All right, Zachary Adams, motion number 3 for Rule 12D2, notice of evidence. Jason Autry, motion 14 for notice of state's intention to use evidence. And related motion, Zachary Adams, number 49, joining Autry's number 14. The state has provided the same notice of response to each defendant. These motions are essentially granted by the court as the party did comply with continuing duty to disclose. If the defendants have any specific issues with the 12 state cites open file, its alibi notice, and states that info requested is neither necessary nor appropriate. I don't want anything destroyed, is what I'm saying. And I know that there are any number of rough notes, anything else. I don't want anything destroyed so that we can assure that full compliance with Brady's being accomplished. Zachary Adams, motion number 8 regarding 804B3, exception to hearsay statements of his interest. Wants the state pretrial to specify in writing and with particularity all statements against interest that the state intends to introduce at trial, and the court to hold a pretrial hearing on the admissibility of the proffered testimony. The state has responded that its filed 12D2 notice has provided open discovery and will supplement as necessary. So any statement against interest, essentially you'll get that. Motion number 26, Zach Adams, motion for pretrial review of victim impacts evidence. State does not object, but states that it is sure the court will follow appropriate procedure. I hope so. The parties will need to follow procedures set forth in the Nesbitt opinion, and the hearing need not be pretrial. Matter of fact, this is something that can be done sometimes while the jury's deliberating the guilt phase. We can check, make sure that testimony during the sentencing phase is appropriate. Number 29, Zachary Adams, motion for agents to provide evidence to the prosecuting attorney. Jason Autry, motion for all agents, officers, and employees to disclose and provide evidence in the possession, custody, and control of the state. The state submits this motion is not necessary based upon open file policy. Motion's intended to avoid any issue of an agency failing to turn anything over to prosecution. I think the parties have been cooperating to make sure that all the information that's out there gets from agents to the prosecutor's office, and it'd be furnished to the defendants. Jason Autry, motion for disclosure of informants. States comply by the Rule 12D2 notice. Jason Autry, motion for preservation, production of evidence sent to other agencies. Motions to seek preservation of evidence in the event defense needs to have it independently tested. State has responded it's unaware of any such evidence sent to another agency which has not been returned. So it's in their possession. Should it require independent analysis, that will be granted. Trial-related motions, Dylan Adams, number 14, motion for exclusion of witnesses, and for the immediate instruction to all potential witnesses for enforcement of Rule 615. The court will closely enforce the sequestration rule and will instruct all witnesses that they're not to discuss that testimony or matters that have occurred in the open courtroom. Okay. Everyone in court will be advised that they're not to discuss testimony that's given in the courtroom with other people, but all persons without limitation might be broad, but court will fully